O'Shaughnessy. I am the Chairman-elect of the Licensing Executive Society, USA and Canada, and I am a shareholder in the intellectual property law firm of Ratner Prestia, based in Washington, D.C. Welcome to IP and the licensing ecosystem. Today we're going to talk about how you can use intellectual property and licensing to boost revenue and gain access to new technologies. These are just a few of the advantages of an effective intellectual property system and the use of licensing. Licensing is first and foremost a business venture. It's all about furthering the business objectives of your company. So what are those objectives? Sometimes a company is interested in building revenue. Sometimes a company is interested in gaining access to new technologies to either supplement their technologies or to move into new markets. Sometimes they're looking for complementary skill sets. Some companies are looking merely for risk reduction. They have identified certain technologies that they may have developed themselves, and they are looking to move into that space, but that space may be dominated by another player who actually already owns intellectual property in that space. Through licensing, you can gain access to those technologies and reduce the risk that you are going to suffer a lawsuit. You might be looking for logistical support in terms of sales and distribution, for example. So a research-oriented enterprise which has little or no sales and distribution infrastructure might be looking to boost that capability, and they can do that by licensing their technology to another enterprise that has the global sales and distribution network, for example. Alternatively, you might be using licensing for knowledge dissemination. You might be working with other enterprises such as universities in order to advance the knowledge in a particular space and to team up with a university. All of those are legitimate objectives undergirding the licensing system. In licensing, your success depends upon your IP assets. So it is essential that you categorize and fully understand your IP. Does your IP reside solely in patents and applications, or are there important trade secrets that your company possesses? Does the company possess a certain amount of know-how? Are trademarks important to your business objectives? What about copyrights? Then there are a whole host of other forms of intellectual property that are generally considered to be a little less commercially significant depending upon which markets you're in. So, for example, in the United States, we have chipworks protection, maskworks protection, in terms of how the chips are actually constructed. So, as part of this process and understanding your IP, you must perform your due diligence. So you must know what the IP strengths and weaknesses are, and then you need to know what your licensee is likely to want or need. And toward that end, you want to make sure that your intellectual property aligns with those wants and needs. What is it that the licensee is looking to do? Why do they want access to your technology? Are there any alternatives that the licensee might be able to use? Does your licensee pose a threat to your business? So frequently in today's world, we have many enterprises that are engaged in what we call co-opetition. That means that they are cooperating in the development of certain products, but in other areas of the distribution chain, they might be actually competing. So while they are simultaneously competitors, they are also collaborators as they develop new technology. So in these sorts of circumstances, the structure and the tone and the nature of the license agreement is extremely important. And we'll talk about that a little further as we move along. So, as you move toward a licensing scenario with a prospective licensee, it is important to first establish what are your essential terms and conditions. Are you or your licensee looking for an exclusive relationship and exclusive access to the technology and the market? Or are you happy to have a non-exclusive arrangement where you as the licensee or as the licensor are happy to disseminate the technology and access to that technology widely? So for example, some industries benefit by giving out very easy, low-cost, non-exclusive licenses. PCR technology is a classic example where it became very accessible, and because it became very accessible, it is used widely throughout the diagnostic market. What about the consideration or the payment that you are looking for your technology? Are you looking for a lump sum payment, or will you be happy with a running royalty? Oftentimes, with a startup enterprise, cash is king. You might want a lump sum payment up front. Alternatively, if you're a going enterprise and cash flow is not a particularly big issue, you might be able to make more money in the long term by having a running royalty, so that the licensee, for example, pays you out of the revenue that is derived by exploiting the license. Are you looking for a fixed exchange of identified assets, or are you looking towards some kind of joint development process where intellectual property will be developed, but you don't yet know what that intellectual property is? What about sub-licensing and other transfers? You have to know whether or not your licensee will be interested in sub-licensing this technology to others, or will they be looking to merely gain other collaborators in their process. So for example, they might want to have certain aspects of the licensed technology manufactured by others. So giving them the opportunity to then contract with others for part of their manufacturing process is also part of the licensing discussion. What about ownership of improvements? A very, very difficult situation. How does one define improvements? How broadly are they defined? What about grantbacks? Oftentimes, technology that is developed while technology is being exploited, sometimes by pure happenstance. Who owns that technology? Are you going to expect your licensee to grant rights in that improvement technology back to you? A grantback is different than an ownership interest. Sometimes you might demand that you retain ownership of any improvements. Sometimes you might just demand that there be rights granted back to you through a grantback clause. So as you're moving through your business scenario in terms of what you're trying to achieve, one of the first things you want to do is do a little bit of competitive intelligence gathering. You want to identify your prospective licensees. Who is it that wants or needs access to this technology? What is the prospect's business model? Is it a fully integrated enterprise, such as a manufacturer and a distributor? Or is it a specialist who is looking for the technology for a very narrow use in a very limited part of the market or the distribution chain? Are they experienced in licensing? A very, very important decision. You need to know whether or not your prospective licensee has gone down this path before. Some companies are not experienced in licensing, and so it's very difficult to work with them because they don't know what to expect. They might be risk averse, or worse, they might be particularly litigious. And if the license goes bad or the negotiations go bad and they're not getting what they want, they might just turn around and sue you. So it's important to know what is the track record. In the Licensing Executive Society, we like to say that that's one of the principal advantages for being a member of the Licensing Executive Society. You become part of a community. You have a network. There are lots of people that you can reach out to and ask about your prospective licensee. You can find out whether or not other people have experience interacting with your prospective licensee. And so through that mechanism, you can more easily discern whether or not it's likely that you're going to ultimately get to a deal. And that's what licensing is all about. You ultimately want to get to a deal where both of you profit, both of you benefit. It's a win-win scenario. So, in addition to their history of licensing versus litigation, you also want to look at your prospective licensee in terms of their technological competencies. Is there a particular space that they are especially technologically competent? Are they world leaders in a particular discipline? If so, you might be looking to tap into that. Alternatively, you might be the world leader. They're looking to benefit from your technological competencies. So technologically speaking, what do the respective parties bring to the table? And what are your market positions? Your market position relative to that of your prospective licensee. Is the prospective licensee a dominant market player, or is it a startup? Those are two fundamentally different scenarios from a licensing standpoint. What are their needs, whether technologically, logistically, what have you? What is it that they are trying to gain access to? And how can you fill it? How can you fill it in a way that best aligns with your competencies, but also gives them what they need so that you can arrive at that win-win scenario? And of course, part of that discussion is, will they in fact really need a license? In other words, can they design around the technology, or do they have alternative, competing technology? Maybe it's not as good, but maybe it's nonetheless functional. If they have an alternative, that's going to affect the way that you approach the licensing agreement, and it's going to affect the way that you value the technology. What kind of consideration are you going to demand at the end of the day? Remember, licensing is first and foremost a team sport. It is essential that you engage a team of experts within your company to deal with the various issues. A licensing agreement is a very complicated legal instrument, but it has very important implications from the standpoint of finance, technology, law, intellectual property. You need to make sure that you have the right people in your organization engaged in the licensing enterprise. So it's important that you pull this team together, but within that team, it's important that you have an understanding early on, before you even begin to approach the other side, who is going to lead the negotiations? Who's going to be in charge of deciding what are the key terms of the deal? Who's going to be the one coordinating with the other side? Who's the one who's capable of actually signing the license agreement at the end of the day? So that person who leads the negotiations should have decision-making authority. It is important that you bear in mind something called the speed of trust. If you can build trust with your counterpart, then you can get to a deal much more quickly. This is why in LES we talk about the win-win scenario. There is a famous handbook or textbook, if you will, called Getting to Yes. And it's all about how do you achieve a successful negotiation to arrive at a win-win scenario where both parties come out happy at the end of the day. So when you're looking to expedite the deal and get it done quickly, you're looking to get to that win-win scenario, and candor and trust and transparency is the best way to get there. So it's important. You don't have to tell the other side everything, but it is important to work toward that atmosphere of candor and trust. Remember also that the business leaders must live with the deal long term. A license is not something that you execute and then put in a drawer and forget about. There must be somebody who is a single point of authority who works to make sure that your obligations under that license are complied with in the long term. And you must have somebody who is in charge of making sure that the license deal makes sense from a business standpoint over the long term. So oftentimes business scenarios change, things move on, strategies are modified, and it may be that over the course of the patent or over the course of the life of the intellectual property, the license no longer makes sense to one or the other party. And in which case it might be time to either renegotiate the deal or terminate it. Part, and I would say perhaps one of the most important parts early on in any licensing deal is arriving at the term sheet. Developing a well thought out term sheet with your counterpart is extremely important toward getting quickly to a deal. So you want to, of course, start off where you have a willing licensor and a willing licensee, and hopefully those willing parties will then do what they can to get to the key issues early on. And the best way to do that is through the use of the term sheet. The term sheet is where you set forth the key terms that the parties are agreeing to. What are those key terms that each side needs? So focus on the important terms. Deal with those things that if you cannot get them, there is no point in going further. The negotiation should end. So these are what we call the walkaways. So avoid getting down into the minutia, but stay up there on the high level with those things that you or your counterpart really need. When you write those down, you get them down, you get them into a term sheet, both sides agree to those key terms, and then you've got a document from which to work from. Then you can start working on the finer points, if you will. It's important to, of course, negotiate in good faith, say what you mean what you say. Don't use the term sheet as just another mechanism to negotiate or renegotiate the deal down the pike. Both parties should understand that once the term sheet is settled, they need to move on. Do not renegotiate the term sheet. It is critical to bear in mind that a license agreement is first and foremost a legal document. The principles of contract law apply. There are certain essentials of a contract from a legal standpoint. Now, I will confess that these principles that I'm talking about hold true in the US. They hold true in most of the advanced economies of the world. But of course, there are always differences from country to country in terms of how contracts are constructed, established, and interpreted. But bear in mind, as a disclaimer, if you will, that my concepts that I'm addressing here are primarily from a US-centric standpoint. So in the US, when we talk about a contract and whether or not a contract has actually been formed, we talk first about a few key components. Is there a legitimate offer that is part of an intent to be bound in an agreement? And is there acceptance of that offer? So this is what we refer to as offer and acceptance. Once there is offer and acceptance, in many situations, there is a contract. But an important part of the contract is also what is the consideration, or what is the payment that one party is going to give to the other. Consideration is generally referred to as a catch-all provision It refers to either the payment or the act or some performance, something you're going to do for the benefit of the other side. Sometimes we refer to the promise in exchange for consideration. So in a license agreement, for example, I might promise that I'm not going to sue you if you use my intellectual property. And in exchange, you're going to pay me consideration. That consideration could be in the form of money. It can be in the form of equity in your company. It can take a lot of different forms. So in common law countries, those derived of the British tradition, there is something called the Statute of Frauds. And the Statute of Frauds says that an executory contract of greater than 1 year in duration must be in writing. So an executory contract, for example, is a contract where performance of the contract is going to take place over the course of time. So an IP license agreement is a classic executory contract because I am allowing you to use my intellectual property over the long term, and you, in exchange, are promising to pay me perhaps a running royalty during the term of your use of that intellectual property. An executory contract, not effective unless it is in writing. But bear in mind that sometimes emails that are exchanged among the parties in what might be deemed to be or thought to be the term sheet stage might be construed to be an actual contract because you are exchanging a writing and one party is offering something, the other party might be accepting that something. So it's important that you bear in mind that sometimes what you think of as casual exchanges of information can in fact be deemed a contract. Let's talk a little bit about licensing principles and the drafting of the agreement. There are certain clauses that are difficult to write. Definitions, for example, are too often overlooked. It's important that you take the time to define the various terms used in your agreement very carefully, very thoroughly. It's important that you carefully define what rights are being granted between the parties. What am I allowing you to do with my intellectual property? Can you just manufacture products, or can you manufacture it and sell it? Can you import my product or my intellectual? Can you import products that incorporate my intellectual property from overseas? So lots of different ways that the rights can be divvied up, if you will, amongst the parties. And it's important that you spell those out very carefully in the context of the license agreement. Remember that a patent gives you an exclusive limited term to exclude others from using the intellectual property. And the intellectual property might have a very broad scope. Your licensee might be interested in using only a very narrow scope of that technology, or they might be interested in using it in only a specific market or a field of use. So those need to be defined within the context of the grant clause. What are the payment terms and the timing? How is the payment going to be based on what sort of principles? Is it going to be per unit? Is it going to be a running royalty in terms of savings made as a result of the use of a process, for example? Many different ways to look at how you can construct the payment and the consideration and the royalty, if you will. Then there is a part of the license agreement also often overlooked and relegated to the legal team, but in fact the implications are borne by the business. And those are what we call risk-shifting provisions. Risk-shifting provisions include representations and warranties and indemnification. Representations are those things that are objective and can be established as a matter of fact. Warranties are those things you might not be able to establish as fact, but you're willing to give a certain representation, if you will, that these circumstances exist, or you will make the other party whole. Indemnification usually means that somehow I'm going to step into your shoes if something goes wrong. So if, for example, you get sued by another intellectual property owner for using my intellectual property in a way that I said was okay, I might be expected to indemnify you or to pay for your legal fees in the event that you are sued by another party. So an indemnification provision obviously can be very, very costly if it goes awry, and so you need to be very careful about whether or not you want to include an indemnification provision within your agreement. This is, as I say, both a legal issue, but it is also a very important business issue, because oftentimes an indemnification is only going to be worthwhile if somehow you are getting compensated for it. In other words, is there something about the agreement where you are getting a better part of the deal, and thus you can take some of the risk, therefore effectively pay the other side if something goes awry. So with definitions, the principal objective is to improve clarity and certainty, enhance brevity and readability of the agreement, provide definitions that are meaningful to the layperson. Remember that if your agreement goes bad, a judge is going to be charged with construing the agreement. The judge won't necessarily know your business, probably won't have a great understanding of the technology, and so it's important that the license agreement be written in a way that a layperson can understand it. With the grant clause, be specific as to the technology and the rights that are being conveyed. Ensure that the grant is consistent with the license being exchanged and the legal rights being exchanged. So for a patent, for example, in the United States, a patent grant gives the owner of the patent the right to make or have made the subject matter of the patent, the right to use it, sell it, offer it for sale, or import it. Those words should be in the grant clause if you are licensing patents. Similarly, if you are licensing trademarks, you have the right to reproduce and use those marks in commerce. Those words should be in the grant clause. Likewise with copyright, where you have the right to reproduce, perform, and make derivative works. With consideration, as I said before, consideration is that which is given in exchange for the rights received. So you might have the financial terms. Is it going to be a lump sum or a running royalty? Are there benchmark payments? What are the reciprocal rights? Are there any reciprocal rights that are being exchanged as part of the consideration or as the sole form of consideration? And as I said before, it could be that you're giving away equity in exchange for the rights. How and when are the payments to be made? And what currency are they to be made in? There are also tax implications that are not worth going into at this point in time, but to my point about the importance of getting a team together, know that there are many other implications at work when we're talking about consideration. Risk-shifting provisions. As I mentioned, reps and warranties and indemnification are what we refer to as risk-shifting provisions. These allow the parties to allocate risk and account for uncertainties. So each has long-term implications. But bear in mind that your risk-shifting provisions can turn a good deal into a bad deal very quickly and many years down the road. So a good deal of thought needs to go into your risk-shifting provisions, and the business people need to be engaged so that they understand what the implications are. When you're drafting the license agreement, remember to use simple and clear terms. It's very easy for us all to get tied up in the notion of using terms that we're comfortable with that have a very specific meaning in a very narrow industry. Try to avoid using technical terms and jargon. Avoid vague, irresolute, and ambiguous terms. Instead, try to use short, simple, declarative sentences. Bear in mind how the words are likely to be later interpreted, and by whom. Remember always that it is the party's intent that is key to contract interpretation. So it is important early on in the agreement to state what your intentions are. Often this is in the preamble of the agreement. And this gives a judge later on a handle, if you will, by which to discern whether or not later events conflict with the party's intent or are consistent with the party's intent. So above all, you want to make the judge's job easy, because the license agreement is ultimately a legal instrument. It is the mechanism by which the judge determines whether or not the parties are acting according to their respective intent at the formation of the contract. As you're drafting the agreement, there are certain rules of construction that you must keep in mind. Contracts are first interpreted from within the four corners of the instrument. That means that judges will try to interpret the contract in such a way that it is discernible what the parties are intending to do from within the agreement. So the agreement should be sufficiently clear to stand on its own in terms of how the parties intend to interact with each other. The contract is always considered in its entirety. So when you put a certain clause in the agreement, understand that a judge can and will rely on each and every clause in the agreement. So make sure that terms and clauses within the agreement do not contradict each other. The terms are used consistently throughout the agreement. Remember that contracts are presumed to be internally consistent, so that if a possible alternative interpretation of a term or a clause is in such a way that it would contradict or be inconsistent with other clauses, the judge will generally not choose that interpretation. The judge will choose an interpretation that is most likely to bring consistency to the agreement as a whole. In most common law countries, including the US, there is something called the Parole Evidence rule. This is something that is easy for licensing executives to get caught up in. The Parole Evidence rule says that no matter what you may have discussed or exchanged in correspondence prior to the execution of the agreement, those writings have no bearing on the agreement itself. It is assumed that anything that was written and exchanged prior to the execution of the agreement was incorporated into the agreement, and if it was not, it was deliberately left out. And so if you have an email from your counterpart that urges one particular interpretation of a clause, and the clause is written in a way that's inconsistent with that interpretation, a judge will generally ignore that earlier correspondence as being parole evidence. So parole evidence says that earlier correspondence cannot be used to contradict the plain terms of an agreement. If, however, the judge determines that there is an unresolvable ambiguity in the terms or clauses of an agreement, it is possible for the judge, at his or her own discretion, to look at that correspondence and to consider it. But the judge is not bound to do so, and you should never expect that you will be entitled to rely on such earlier correspondence. So now you've done your term sheet, you've written the agreement, the parties are happy, you've got to that stage of the licensing negotiation where it's time to close the deal. It is extremely important. I know it's very, very easy for anybody engaged in this exercise who gets fatigued reading the same agreement over and over again. But nonetheless, before you execute the agreement, extremely important to carefully review all terms. Make sure that the elements of your prior correspondence are included. Make sure that the agreement is entirely consistent with the term sheet. Make sure that it is consistent with your objectives. Oftentimes, here is a good time to get a second pair of eyes to read through the agreement. Make sure that there's not something in there that was unintended. have you maintained strategic alignment in the agreement with what it is that got you into the licensing negotiations in the first place? These are all things that you should carefully review before you actually execute the agreement. Once executed, now it's time to develop a compliance plan. Make sure that there is somebody specific and identifiable who has authority and obligation to follow through with all of your promises and obligations within the contract. So develop a compliance plan. Make sure that you have that single point of authority, that person, an identifiable person who's going to make sure that all of those obligations are met. And then that person or somebody affiliated with that person should be engaged in an ongoing assessment of purpose. In other words, does the agreement still make sense? It might be 5 years down the line. Does the agreement still make sense? Is this market still important to you? Are you still making money? It could be that you're looking to actually spin off that business unit. Maybe the license agreement doesn't make sense to you anymore. It could be that it's an essential part of that business unit's strategic plan. And so spinning it off means that the license agreement is that much more important. Do you need to go back and renegotiate the license? Do you need to make sure that it is renewed properly such that when the company is spun off, there will still be a good long term of the license agreement left remaining so that profit can be derived? These are all part of your ongoing assessment of purpose. Well, that concludes our discussion today. I hope this has been a meaningful and worthwhile introduction to IP and licensing and the ecosystem within which it works. So thank you very much for your attention and good luck.